Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And tonight, we are going to be talking about sexual assault. Because why not? Why not? Why shouldn't we talk about sexual assault? today of all days, if that's what it is. That's what it is. So guys, I've got some documents here. Yeah, I know the mustache and beard are gonna go get their trim job very soon. Very soon. For or against. All right. What are we doing here? What are we talking about? We're talking about sexual assault. So I've got these documents, okay? These documents are fresh. These are fresh documents. We're going to talk about a case that is going on in a high school. So it involves minors. So their names have been redacted. They've been replaced with initials, as is kind of the common procedure in identifying minors in a lawsuit. And something needs to happen here. Oh wait, no, I've got this thing. I've got this other whiskey. This little guy. We're gonna start with this. All right. Joscopy, yes. Yes. I'm going to be streaming tomorrow. Let me talk about that real quick. We're going to talk about tomorrow. We're going to have John Delarose. He's a comic artist who is Comicsgate adjacent. His publisher is a guy named Vox Day. I don't know if you've ever heard about Vox Day. We'll get to the Maker's Mark, Wandering Wojak. If you guys heard of Vox Day? Anyway, so John Delarose is publishes comics along with Vox Day, or I guess more appropriately, he's an artist. He is suing Worldcon, which, if I understand it right, is a cosplay convention that kicked John Delarose out because they called him a Nazi racist. So they threw him out of the convention. So we're going to talk about that, about the censorship, the thought and speech police. We're going to talk to John tomorrow, and then of course, if you don't know, Vox Day's one of his other publications that he does with a guy named Chuck Dixon. Let's see, Alt Hero Q. They were on the fourth book, was on Indiegogo, and it just got pulled. Something like $70,000 had been raised on Indiegogo, and it got pulled for an unnamed term of service violation earlier today. So I'm going to hopefully be talking to John about that. And then we'll see if we can get either Chuck Dixon or Vox Day on the channel as well to talk to them, because we got to stop. We got to stop the censorship. Agree with people, disagree with people. Got to stop the censorship. So that's coming tomorrow. Tomorrow, same time, 11 p.m. Thank you. No, this isn't Kavanaugh test, but I think this might be interesting in light of all of that. We're going to talk about the burden of proof in a sexual assault case. So here we go. Corey Jamnick says, do police officers have different standards for testimony? Can you be convinced just from a police officer saying or convicted, I think is what you mean, just from a police officer saying he saw you do something illegal? Yes. Yes, you can. Absolutely. Absolutely. I am not the IPA debate. I'm not a big beer person at all. IPA's not my thing. So we'll see about Vox. We'll see whoever. I don't know if he's going to want to come on here. Made fun of him on this channel, all in good fun. But that's where we're at. But we are going to have a good conversation with John Delarose tomorrow, and then we'll see how it goes. We'll see what happens after that. But that's tomorrow. Tonight, we are bringing you live sexual assault. That didn't come out right. Ooh. That's good. I don't even know what that is. It's some USA whiskey. Not important. We'll figure it out later. Here we go. So what I'm going to read to you now, this is an affidavit of probable cause. This is a statement made by a police officer. The police officer is telling the court what grounds they have to make an arrest. What grounds they have to hold you. Because you can't just arrest someone. You can't just do that. As fun as that might be, if you arrest someone without probable cause, you have to let them go. So if you want to hold them, they have this probable cause review. The affidavit of probable cause is how a judge determines, based on a set of facts, whether or not the probable cause is sufficient to go ahead and hold them longer. So here we go with this affidavit of probable cause. There's another one. This isn't the only one, so bear with me. But I want you to read what the allegations are here, because I think it's important. So on October 4th, 2017, so this happened about a year ago. Fan Advocacy Network, we'll talk about that later. Let's see. On 10/4/2017, I attended forensic interview at Butler CAC. Sue Counts conducted interview with AV. AV is alleged victim. I don't know all of the terminology because it's from a different state than mine, but I'm going to try and help out. AV is alleged victim and AP is alleged perpetrator. Okay. So, alleged victim reported that on Wednesday before the Junior Olympics, date later confirmed with victim's parents as 7/19/17, she was working at the concession stand. The stand was closed and the garage doors were shut. She was sweeping the floor at approximately 1800 hours when AP approached and began, the perpetrator, alleged perpetrator, approached and began to fill up his water bottle, and she did not think much of it. Perpetrator sprayed her shirt with a water bottle. She believes she was wearing a white shirt and shorts. AP stated that she was wet. AV in turn sprayed AP with water. As AV walked past, AP smacked her butt. She, again, did not think much of it, but he continued to spray her shirt, stating, "You're wet, you're wet." AP then touched her chest area above her shirt, and she pushed his hand away. She backed up to the wall and tried changing the subject so he would get the hint and stop, but he did not. He left and she continued her work. AP returned stating, "You dried up really fast," and sprayed her again with water. He approached her and put his hands inside her shirt. She pulled his hand away and told him no. She moved away from him, hoping he would get the hint, but he did not. She walked around the table and AP walked around the table from the other direction and touched her butt. She began cleaning the soda machine and could not get one of the nozzles off. AP assisted her with removing the nozzles from the soda machine. AV stated that AP kept stating, when we gonna hang? AV told him they weren't. He placed his hands beneath her shorts, touching her bare buttocks. She moved away from him and he began touching her, quote, vaginal area above her shorts. He attempted to put his hand inside her shorts, presumably to touch her vagina, but she moved quickly so he could not. He tried putting his hand on the front of her pants and she stated, "No, no, no, no." AP at one point stood behind her, placed his arms around her upper chest neck area, and tried putting his hand down her shirt as she kept moving or slapping his hand. He asked AV again when they were going to hang, and she stated they weren't. AP then exited to go back to the pool. So I verify that the facts set forth in this affidavit are true and correct to the best of my knowledge or information and belief. This verification is made subject to the penalties of Section 4904 of the Crimes Code, 18 PACC, so Pennsylvania Criminal Code 4904, relating to unsworn falsification to authorities. Oh, no, I've not unboomered the heading. All right. Let's, yeah, I guess that's kind of funny in context. Oh my goodness. I got nothing. Sexual assault and the burden of proof. Whoa. We'll fix that. All right. That's good enough for now. Sexual assault and the burden of proof. Thank you. Thank you, Andrew, for pointing that out. All right. So that's an affidavit of probable cause. based on that, that's a statement from a, as long as this person isn't a criminal informant, if it's a civilian informant, that the cop has no reason to disbelieve, this will be accepted as fact and will probably be more than sufficient to sustain an arrest for criminal sexual conduct. All right. So we've got petition alleging delinquency. This is juvenile delinquent. We're going to skip all this and we're going to get to the next plaint. Well, here's the complaint. Oh, I feel great, Power Cage. So the complaint, we have indecent assault without consent of others. We have subject other to physical contact. We have harassment, course of conduct with no legitimate purpose. Those are the 3 charges. Here's a 4th charge, disorderly conduct, hazardous, physical, offensive touch. So there we go. I think that's it. So then we have this consent decree order. Kikagazumi says, your metal intro is great. Thanks, buddy. It was made by the Cucksockers and Uncle Buck, who's a buddy of mine. He made the music for that. So thank you. Thank you, guys. You should definitely check out their stuff. It's fun. It's fun. So here's a pre-adjudication disposition hearing. Juvenile is not admitted to any of the offenses. The rulings on the offenses, the findings on the offenses set forth in Exhibit A attached herein. It is ordered that a consent decree shall be commenced for a period of 6 months, scheduled to expire on July 24th under the supervision of the County Juvenile Probation Department. Proceedings are suspended until further notice of the court. The juvenile shall be subject to the additional programs and conditions as specified in the attached document. So additional programs and conditions would be like probation, therapy, those sorts of things. Any other conditions? And then there are consequences for violating this. So it's going to be like a restraining order and stuff like that. So here are the delinquent acts. Here are the additional programs and conditions that he has to do. Follow the rules of probation as established by the probation officer. Court costs in the amount of $61.50 made to the Butler County Clerk of Courts. Victim compensation fund fee of $25 to the Butler County Clerk of Courts. Pay a probation supervision fee in the amount of $50 made payable to Butler County. Parental liability set at $136.50. So his parents have to pay this extra amount with a minimum monthly payment of $25. Undergo random drug screens. I don't know how they do it in Pennsylvania, but drug screens in Minnesota are paid for by the alleged perpetrator. They get very expensive. Couple, $400, $500 a month because it's random and each one costs money. You also have to call in like every morning and then show up within a specific amount of time if they tell you need to be there. So, that's random drug screens in probation is actually a really, really high burden on people, especially low income people. And I can't stress that enough because a lot of the people who are charged with it. But why are there random drug screens on this? We've no allegations that drugs are involved. Why is there a random drug screen? That bothers me, but whatever. So then there's a review hearing to be held July 11th, 2018. This was note on January 24th, 2018. So we've got 6.5 months until the review hearing to review this. So they're under this for at least 6.5 months. And any violations will result in the consent decree being withdrawn by the district attorney and the scheduling of a pre-adjudication conference before the court under the underlying charges. So I don't know, but I think that what this is this is a juvenile. Here we go. Yeah, successful completion of the conditions of the consent decree eliminates the requirement for fingerprinting and photographing. So this is just release conditions. Okay, here we go. Next. So this is all signed by everybody. Good job not redacting his name, idiots. They redact his name everywhere but his signature. Nice. Good work. Ryan English, do you think they did an observed piss test so they knew what his... Wow. what his dick looked like in case its appearance became a matter of evidence. I don't know. I don't know. Maybe. All right. So then we have another thing. I'm not going to go through all of these documents because some of these are not really useful. Let's get to this affidavit of probable cause. So this is another set of charges. This is on March 26th, 2018. Same alleged perpetrator. All right, this is the same alleged perpetrator, but I believe this is a different alleged victim. Okay, so here we go. On March 26, 2018, I received information from Officer Hunter Ryan, a Jackson Township police officer and Seneca Valley resource officer, that a female juvenile had reported an incident that occurred on Friday, March 23, 2018, at her residence to the guidance counselor's office. Due to the information provided by Officer Ryan, I notified Butler County Alliance for Children, and interviews were scheduled for at their facility. On March 30th, 2018, I responded to the Butler County CAC, where forensic interviewer Joshua Strelbicki conducted an interview with the AV. Guys, I can't stress enough. Like, this is one reason you don't talk to cops. Like, this, obviously not here, but just pay attention to what's going on outside of this context. These people professionally do interviews with people every day. Victims, alleged perpetrators, they're doing interviews with them. They're talking with them. This is their job. The reason you don't talk to cops and you let an attorney do it is because cops are very good at these interviews that they do every day. They're better at it than people who are never charged, never questioned with a crime, in a criminal act or anything like that until the time that they show up. So just know they have professional interviewers who are very good at their jobs. They're very good at getting information out of people. They're really kind of good at discerning facts and situations. RJ Phoenix 22. Yes, sir, I am. That's what we're going to talk about today. Please, no spoilers. All right. So yeah, professional interviewers here, guys. The alleged victim reports she had two female friends at her residence. With her parents' permission, while they were out for the evening, at approximately 8 p.m. to 8:30 p.m., the front door opened and the alleged perpetrator enters the entry hallway inside the residence. The alleged victim approaches the perpetrator and tells him he needs to leave because her parents were not home and she is not permitted to have any boys over. Errant apostrophe. Good job, police. They always have errant apostrophes. The alleged perpetrator took off his shoes, and he said he was not leaving. Alleged victim said she is not aware of anyone that invited the AP to her residence. At about 8:45 p.m., the AV went into the kitchen, and the two females, witnesses 1, ES, and witness 2, HR, went upstairs. Upstairs is one word, cops. Please. Please. Let's see. The AP was in the kitchen with the AV. When the AP grabbed hold of her left arm, and put his arm around the AV and pulls the AV back against him. AV tells him no and begins to slap and kick the AP. AP then grabbed hold of the AV's arm and pushed her hand down the front and inside his black gym shorts. AV said her hand first was on his stomach area, then pushed further down to the area of the upper thigh and hip, and lastly, actually on his penis. At this time, W2HR, witness 2 HR, who was interviewed at the Butler County CAC on April 5th, 2018, had come downstairs and saw the AP and AV in the kitchen. Witness 2 HR said she saw AP holding the AV close, and he had the AV's wrist and had the AV's hand down his pants. When the AP saw witness 2 HR, he quickly pulled the AV's hand out of his pants. The AV and witness 2 HR went up to the bedroom and were followed by the AP. Once in the bedroom, the AV said the AP had a phone charger cord. The AP struck the alleged victim with the charger cord on the thigh and stomach area, leaving a red mark of welt, which was later photographed by the AV. When the AP had struck the AV with the cord, he said, "Ooh, I bet that hurt." Witness 1 ES and witness 2 HR left the bedroom. The AV said the AP then pushed her twice, causing her to hit her head on the wall and pulled her hair back. AV ran downstairs and grabbed her phone and told the AP, "You need to leave or I'm calling the police." Again, verifying the facts set forth in the affidavit as true. So that is another statement. So this guy, man, that's two incidents of pretty clear assault. We've got witnesses. We've got a photograph of a red welt caused by a charger cord hitting allegedly the thigh and stomach area. I don't know if they were both photographed or not because the grammar is bad. But yeah, so there you go. So he is charged with a couple different crimes here: indecent assault, forcible compulsion, criminal trespass, enter a structure, simple assault. Let's see. So we have a probable cause hearing and pre-adjudicatory detention / shelter care. So this is going to a juvenile detention center. Probable cause exists that the juvenile committed the following delinquent acts. Juvenile is currently placed on a consent decree and new allegations were received for indecent assault, criminal trespass, and simple assault. Shelter care is required. The continued placement of the juvenile in shelter care is required, so he is going to a juvenile detention facility to await trial. It is contrary to the welfare of the juvenile to remain in the home of Mickey and Alicia Flood. Mickey and Alicia Flood are the juvenile's parents. Reasonable efforts made. Reasonable efforts were made to prevent removal of the juvenile from the home. I guess those reasonable efforts are that they gave him a consent decree the first time. So then we have the juvenile should be under the care and responsibility of the Butler County Juvenile Court Services. And I'm sure they're good parents. So then we've got the next scheduled court date would be April 18th for a review of the consent decree. This is done on the 24th of April? May, probably. May? No, April 18th is the consent decree review. I don't know what this, March? When is this? Do they have this dated? I have no idea. I have no idea what date that is. Good job. It says it was filed on April 24th, but that's, if the consent decree review is 4/18, I don't know. That's a weird thing. So recommendations. Juvenile Court Services respectfully makes the following recommendations on behalf of the above named juvenile. T continue to be detained at Keystone Education Center in shelter care and in the custody of Butler County Juvenile Court Services. This is the least restrictive placement that is consistent with the protection of the public and best suited to the juvenile's treatment, supervision, and welfare, and that this juvenile is a danger to others and that he has 2 pending sexual assault cases. 10-day adjudication consent decree revocation hearing is to be scheduled for April 18th, 2018 at 2:30 p.m. Blah, 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 blah. All right. Paul Delaney says shenanigans are afoot. Well, we'll see, I guess. So then, same thing. He does get released, subject to the following conditions of release: no contact with the victim or the victim's family. Homebound schooling is set up by parents and the Seneca Valley School District. Pre-adjudicatory supervision. Juvenile shall be subject to electronic monitoring. So he gets an ankle bracelet where he cannot leave his house. He's stuck at home. That's the result of that 4/18 hearing, that he will be homeschooled. Let's see. Do we want to read these? So, okay. So, guys, what do you think? Let's see. Talk about me. Talk about what's going on here. Let's review. So you got the first charge, which is made by a victim, civilian informant, no noted criminal history. The way that these probable cause statements work on a warrant for some sort of arrest or detention tend to be that if the person is a known criminal informant, they have to inform the court because their credibility would be in question, and then they have to overcome those credibility questions with supporting stuff. Like, you can take a statement from a criminal informant as long as you tell the court, I worked with this criminal informant before, I have reason to trust their judgment, they don't have any sort of conflicts in this story. So, but outside of that, if it's not in if it's not in the probable cause statement, this is sufficient to make an arrest and to carry a charge, because you have a victim who will claim these charges, and whether or not they go to trial is a different question, because right there it's a he said, she said, right? He'll say, I didn't do any of this. She'll say, yeah, you did. Now, the second charge is a little bit different. The second charge involves 2 witnesses. The second charge involves a mark and photographs. We have some physical evidence. All of this stuff kind of leads to some really unfortunate conclusions for the alleged perpetrator. He starts to look less like an alleged perpetrator and a lot like a real perpetrator. Zephael, that's a good question, but that's what they do. I don't know. Not my job. Yes, I mean alleged victim. I just get tired of saying alleged so much. So here we have 2 very credible eyewitness testimonies against an alleged perpetrator by alleged victims, along with corroborating witnesses and physical evidence. Rashizzle. Yeah, there's a reason that we're seeing these juvenile records. So, yeah. So here we go. Here's the interesting thing, I guess. Date of statement, April 15th. So this is April 15th. Statement of AK. Let's keep going. Keep going through this. Keep in mind, these are all very professional police officers and interviewers. They're very good at their jobs. They're great. They are absolutely fantastic at doing their jobs. And I am not saying that in any sort of irony here. The police have done their job 1,000% in this case. They have done a great job. So have the interviewers. They have gotten very, very incriminating testimony from obviously credible witnesses. And they have put that together into the case. So let's see what happens next. AK is a sophomore at Seneca Valley Intermediate High School. A is friends with CS, ES, and HR. I'm thinking CS is the alleged victim in the second case, because ES and HR are the 2 witnesses. But I don't think they ever say the alleged victim's initials. Maybe they did and I just forgot. All right. On 3/22/18, CS texted A to come to her house on March 23rd, anytime after 5 p.m. 3/23/18 at 8:07 p.m., CS sent A message through Instagram, so I'm guessing you can't come over. A did not go to the Seaman residence on 3/23/18. A went to the home of ES on 3/30/18 at approximately 12 p.m. On that date, and in the presence of E talked to HR and CS for the purpose of discussing their respective stories regarding events at the Seaman residence on 3/23/18. A heard E discuss with H on the telephone and with C on FaceTime the order of events and a not to include and a note, there's an E missing, to include in their respective stories the Snapchats and the alcohol that was consumed by the girls. HR admitted to A that it was H that invited TF to the Seaman residence on 3/23/18 using the telephone and Snapchat account of CS. A provided this statement in the presence of her mother and father, Matt and Jennifer Kaufman. All right. Statement of MM. MM is a freshman at Seneca Valley Intermediate School. M is an acquaintance of ES, HR, and CS. M lives next to TF. TF is the alleged perpetrator, Tyler Floods. Because they don't censor his signature. Good job, dummies. During the first week of April, M was in the girls' restroom at school with a number of girls, including ES. M heard ES state that CS exaggerated her story about the events of 3/23/18 and stated how could CS remember because she was passed out drunk. M believes that there was a live stream on Instagram on which both ES and HR stated that CS exaggerated and made things about the events. Made things up is what they mean to say about the events of 3/23/18. The plot thickens. M made this statement in the presence of her father, Mark Malone. So it's a good question why we're even bothering to censor the minors' names when all of their parents are named. And actually, if you look really close, you can see through the lineouts because they really should have done this like on Adobe instead of with an actual Sharpie marker. But, you know, that's okay. That's okay. Statement of CH. C is a sophomore at Seneca Valley High School. He was at a friend's house, PJ, in Cranberry Township with 10 or so other people on April 21st, 2018. ES was also there. C had never seen ES outside of school and never spoken to her before a brief conversation with her on April 21st, 2018. On April 21st, 2018, C heard ES say that CS lied about TF touching her. C asked her what she knew about T and C, and she repeated that CS lied about, quote, everything about TF. ES stated this while C openly recorded her on a Snapchat video. C saved the video on his phone. The video has the date of April 21st, 2018, and the time of 11:02 p.m. This statement was made in the presence of C's mother, Colleen Hayes. All right. So I, so-and-so, am providing this written statement after being interviewed by Raymond J. Melder, a licensed private investigator, and in the presence of my mother, Lynn Reyna. I have been given the opportunity to discuss this matter with my parents, and I freely and voluntarily provide this statement knowing that it will be utilized in the case of Commonwealth versus TF. I have also been told that Raymond Melder is an investigator for attorney Michael Pauck and TF. So this is the alleged perpetrator's investigator getting a statement from whoever this person is. Whoever this person is. H. Reyna. All right. On Friday, March 23rd, I attended school. I came home at 3 o'clock. I received a text from C asking to come over and hang out. C's mom came and picked me up. C and E were in the vehicle. We picked up pizza and went to C's. C's mom stayed 10 minutes, then left. Everyone was sitting around on our phones eating pizza. Then we went to go straighten my hair. Then we went back downstairs and sat on the couch in the living room. C and E went and grabbed alcohol drinks from the downstairs. Who wrote this? They grabbed alcohol drinks from the downstairs. One bottle was a tall bottle with an orange beverage in it. C told E not to drink too much. Wrong too. Good job. Because her mom would find out. C drank a lot more alcohol than E. Something had half of one and C had several. Ooh, this is getting hard to read. While drinking in the living room, C was texting J to come over. C told E and I that J couldn't come over. C sent and received text messages at this time. E took C's phone because she wanted to text her boyfriend because her phone was shut off. E and I are sitting on the living room couch at this time. E sees a Snapchat on C's phone from T and clicks on it, and it says, I'll be there in a couple minutes. This is a notification on top of the screen. E and I saw. C then told E to give her back her phone. Me, C, and E remained sitting in the living room, and about 10 to 20 minutes, T appeared at the door. The main door was open, and the screen/glass door was shut. T came in and took off his shoes and played with C's dog. T did not talk a lot and did not drink. C appeared to begin to be intoxicated before he arrived, but got worse and worse as he was there. The whole situation became kind of awkward when everyone was just sitting there. We stayed in the living room having small conversations. E and I went upstairs less than a minute before I went back downstairs and went to see what C and T were doing. C was wearing her black cheer shorts. I see T and C in the kitchen hallway. C is leaning up against T. No one was leaning against anything, just standing there. I saw C's hand in T's pants. I don't believe T had his hands or arm around C. It looked that C was all over T because she was up against him. C gave no appearance that she didn't like it or was uncomfortable. When T and C both noticed me, they both jumped and moved away from each other. Then T, me, and C went to C's bedroom. E was up against the wall on the bed. C was laying straight out on the bed. I was at the end of the bed, and T was on C's chair. Wow, this is weird. It's kind of awkward, a legal conclusion. Yeah. T was playfully swinging his phone cord and accidentally hit me with it. Then T hit C with it in the leg and stomach, and C didn't say anything to him to stop. So he just stopped. E was sitting up against the wall, just sitting on her phone, and E and I were minding our own business, and we were vaping. Oh, guys, we've solved the case. We've solved the case. Vaping is involved. Case closed. C was still acting intoxicated at this time. T left after E told him C's parents were on their way home, and T said, yeah, my mom should be home soon too. After T left, C seemed to become sober right when he left. E and I were in the bedroom the whole time and did not see or hear T slam her head off a wall. C has said she felt awkward with him before because of bus issues. After this incident, C has been adding to the story that isn't true, like T hitting her head off a wall. C told me not to tell the school about the alcohol. And then she signed it. Okay. So then we have this 30th day, August 18, on the motion of the Commonwealth. The above caption matter is withdrawn. This 30th day of August 2018, on oral motion of the Commonwealth, the above caption matter being resolved by consent decree, the Commonwealth is going to close the case as of today. So, he is done. He is done. And by done, I mean the court is done trying to press charges against him. Did we follow what happened there? We had severely contradictory testimony suggesting that he was there by consent, that everything he was doing appeared to be consensual, that there was no alleged assaults or batteries that occurred. The juvenile is released from further supervision by this court, and this case shall be marked closed. There we go. So, once you got the phone recording on Snapchat of the chick saying, they're lying, really exaggerating everything. Then you got an investigator coming out to their house, talking to her, getting a statement that contradicts the victim's statements. And now we have a closed case, right? There's no guilt for this kid. But that's not the end of the story. That's not the end of the story at all. And that's not why we're here, is it? We're here to talk about the end of the story. Or the beginning of the end of the story, because this is now ongoing in a different way. But notice this. This was September 10th, 2018. This kid was initially charged on January 24th. He's been under detention. Think about being a man, guy, kid, boy, teenager. What are these things? Think about being a kid in high school. Think about being charged with sexual assault of your classmate and what that means. Think about it. Think about what happened to this kid over 9 months. 9 months. Well, 8.5. 8.5 months. If he went free, I don't know why it's stamped delinquent. I'm not sure about that, but let's see what happened next. Here we go. This is the new thing. This was just filed on the 1st of October. This is Michael Flood Jr. and Alicia Flood individually and as parents and natural guardians of TF, a minor, versus George Villegas, I think I'm pronouncing that right, George Villegas Jr. and Pam Villegas individually as the parents and natural guardians of Megan Villegas, David and Christy Shirk individually and as parents and natural guardians of KS, a minor, David and Christine Seaman individually and as parents and natural guardians of CS, a minor, Chris and Kimberly Salency individually and as parents and natural guardians of ES, a minor, David and Lynn Reyna individually and as parents and natural guardians of HR, a minor, Seneca Valley School District, Butler County District Attorney's Office, and Butler County, Pennsylvania defendants. So they have brought a lawsuit, and we're going to read it. Okay, so bear with me. This is kind of getting back to the old school aspect of the channel. We're going to read this lawsuit, and we're going to hear the rest of the story from the parents and the kids' perspective, filtered obviously through their attorney into some charges against some people, and we're going to see. And I can't wait to follow this case and find out how this turns out. Slithering Peanut says it means it's safer to be gay than ever dealing with girls again. Yeah, I think so, buddy. All right. Ladies, if you want to know why it's starting to get hard to find dates, here's a reason. Let's talk about this. And now, come the plaintiffs, Michael Flood Jr. and Alicia Flood individually and as parents and natural guardians of TF, a minor, by and through their attorneys, Craig L. Fishman, Esquire, and Shindovich, and Fishman, PC, and file the following complaint. Mean Girls, Megan Villegas. Mean Girl. Like, it's good to label things, I guess, in an identifiable way. They're already framing the alleged perpetrators. Now they're the alleged perpetrators with Mean Girls, right? They want to invoke a quality Lindsay Lohan movie. They want people to think of these as the plastics, as Mean Girls. Mean Girls, Megan Villegas, KS, CS, ES, and HR conspired in person and via electronic communication devices to falsely accuse TF of sexual assault on 2 occasions. TF was forced to endure multiple court appearances, detention in a juvenile facility, detention at home, loss of his liberty, and other damages until several of the girls reluctantly admitted that their accusations were false. Even though the girls admitted their misconduct, TF was further harmed by the Seneca Valley School District and the Butler County District Attorney's Office, which are biased in favor of females who accuse males of sexual assault, and biased against males falsely accused of sexual assault, and who are the subject of harassment and bullying at school. Although TF lost his liberty and his civil rights were infringed upon, his tormentors suffered no repercussions as a result of the lies they told. Remember, lying to the police, falsifying a police report, punishable typically by some sort of felony charge. Parties. I'm not going to read all of the parties because we've covered them. Doesn't really matter. At all times, we'll talk about the people who aren't named earlier. At all times pertinent to this matter, Aaron Mazer was employed at the Seneca Valley School District as an assistant principal. At all times pertinent to this matter, guidance counselors were employed by the Seneca Valley School District. Defendant School District is a government entity and or political subdivision of the Commonwealth of Pennsylvania. Defendant Butler County District Attorney's Office is a governmental entity and or political subdivision of the Commonwealth. Butler County itself is a division of the Commonwealth. Jurisdiction. Plaintiffs bring these claims under 42 U.S.C. 1983, Title 9 of the Education Amendments of 1972, 20 U.S.C. 1681 at sec and state law. So the big ones here, this is what brings it really into federal court. is 42 USC 1983 and then Title 9 of the Education Amendments. Oh my goodness, I'm sorry guys, I'm yawning. Brr. All right, so you bring a 1983 claim. This is a very commonly brought action. A 1983 claim is where you are bringing an alleged violation of your civil rights under color of law. So usually you've got a government entity or a law enforcement agency depriving you of civil rights and doing so as if they had a right to do it. Right. So a police officer falsely arresting someone would be a 1983 claim. And a police officer battering someone while they're in custody with excessive force is a 1983 claim because you have a right not to be hit. And if it's done under the color of law, and without some sort of justification, that's a 1983 claim. Court has jurisdiction over these claims pursuant to 28 USC 1331, 1343. Venue is appropriate in this court under 28 USC 1391 because a substantial part of the events giving rise to the complaint occurred in Butler County, Pennsylvania. Factual allegations. So here we go. Here's their side of the story. I think there's a 1984 claim. I just don't know what it is. You have to look up 18 USC 1984 and see what it is. At all times pertinent to this matter, Michael Flood, Jr. was employed as a teacher at the Seneca Valley School District, and TFKS, CS, ES, and HR were students at the intermediate high school. During the summer of 2017, TF was employed as a lifeguard at the Zalinapool Community Pool in Butler County, Pennsylvania. Megan Villegas and KS also worked at the pool. In June 2017, Megan Villegas, a supervisor, advised others that she was going to get TF fired from his job at the pool. After conspiring with Megan Villegas, KS falsely accused TF of committing a sexual assault at the pool on or about July 19, 2017. Megan Villegas was not at the pool at the time of the alleged assault, having departed the premises to run a personal errand without clocking out. Nevertheless, Megan Villegas advised Brandon Coneby, president of Aquatic Watch Incorporated, which supplied lifeguards for the pool, that she had been present at the time of the assault and that KS told her about the assault the next day after it had occurred. Upon information and belief, Megan Villegas conspired with KS and assisted KS in preparing her statement in an effort to cause TF to be terminated from his job at the pool. TF was fired at his job from his job at the pool on or about July 26, 2017. KS advised Megan Villegas and other pool employees of her false allegations regarding TF, but she did not inform her parents. On or about October 2nd, 2017, Section 1984 omitted. On or about October 2nd, 2017, students at Seneca Valley Intermediate School advised TF that KS informed others that she would do anything to get TF expelled from school. On that date, Alicia Flood spoke with Aaron Mazer, assistant principal at Seneca Valley Intermediate School, where TF and KS were enrolled, and advised her of KS's threat that she would do anything to get TF expelled. On or about October 3rd, 2017, after she was overheard by a teacher telling other students that she had been sexually assaulted, she still had not related her false accusations to her parents. KS was called to the office at a Seneca Valley Intermediate High School guidance counselor, where KS falsely accused TF of sexual assault. The listen and believe, y'all. Listen and believe, right? The guidance counselor reported TF to Childline, a program operated by the Commonwealth of Pennsylvania for reporting of child abuse and neglect. Sue Counts, her name is Sue Counts, a forensic interviewer employed by the Butler County Alliance for Children, conducted an interview of KS on October 4th, 2017, and KS continued to falsely accuse TF of sexual assault. Her vision of events changed just prior to the end of the interview. At 20 minutes and 57 seconds of the interview, she proclaimed, "I just don't like to hear him, TF, talk. I don't like to look at him. I just don't like him." Due to gender-based discrimination against males falsely accused of sexual assault, Ms. Counts did not ask KS whether this animosity predated the alleged sexual assault, and Ms. Counts did not follow up on inconsistent statements in KS's recorded interview. Villegas and KS repeated their lies about TF to other students and anyone else who would listen to them. On October 8th, 2017, TF was charged with the offenses of indecent assault and 2 counts of harassment. A petition alleging delinquency was filed on November 1st. Michael and Alicia Flood retained and paid for legal counsel on behalf of TF to defend against the false allegations of KS. The Butler County District Attorney's Office offered a plea deal of a consent decree in which TF did not admit the false allegations, but would be under the jurisdiction of the Butler County Probation Department for 6 months and would be required to stay out of trouble for 6 months, failing which the consent decree would be withdrawn and the underlying criminal charges reinstated. The Floods accepted the consent decree. Guilty, right? He pled guilty, y'all. He didn't admit to being guilty, but he had to accept being guilty. Why? Why would you do this? Well, just stay out of trouble for 6 months. It'll go away. Just stay out of trouble for 6 months. That's easy to do. Most of you have gone your entire lives, or the vast majority of your lives, being out of trouble. 6 months is a pretty small stretch, even for someone who's, 15, 16 years old. So, someone slithering peanut. Yep, the cops certainly did their jobs. They did, didn't they? They did exactly what the cop's job is to do. It's to find someone who is guilty of a crime. More appropriately, to find enough evidence to convince the court that someone is guilty of a crime. Okay? That's the police officer's job. If you want to know the underlying reason why you don't talk to the police and why you have a healthy, respectful distrust of them, look how good they are at their job. They found plenty of evidence to convict this kid, to convict him by getting him to take this consent deal, to take this plea agreement. They found plenty of evidence to put enough pressure to do that. So here we go. TF's activities were severely curtailed during the 6-month period following entry of the consent decree. He's innocent. Why didn't he just fight it, right? Why didn't he just fight it? His dad's a teacher. I'm sure they could afford legal counsel to fight this fight. I'm sure they could do that. I'm sure they could afford to fight a sexual assault case with a sympathetic victim. That'd be just fine. It'd be just fine. Remember that Cody Wilson stream? Right? Remember, if you haven't seen the Cody Wilson defense, how you would conduct a defense for Cody Wilson? Those defenses are expensive, very expensive. So what do? You pay 10, 15 grand to defend a criminal sexual assault charge? Maybe 20, maybe 30 if you're going to trial. Depends. Or do you take a consent deal? Do you take a plea deal? What do? All right. He was harassed at school by other students. Yeah, he's a sex offender, right? He's a rapist. He's a woman assaulting rapist. Including male student MB, who put a piece of masking tape proclaiming predator on the back of TF's shirt during chorus class, a large gathering of people for all to see. TF continues to be harassed by other students, even though he did nothing wrong. Just like Hitler, right? Right, TF? You little mini Hitler. On March 23rd, 2018, TF received a Snapchat message sent from CS's mobile telephone inviting TF to hang out with her and her friends. TF was advised that CS's parents, David and Christine Seaman, were at home. TF arrived at the Seaman residence, knocked, and was let in by HR through the front door. Removed his shoes at the door and entered the home where CS, ES, and HR were consuming alcoholic beverages. CS was drunk. Her parents were not present. The female students discussed purchasing marijuana. TF did not partake of any alcohol that was offered, visited briefly, and departed the residence. Eggs were thrown at the Flood house on March 23, 2018 by individuals later determined to be CS, ES, and HR, and the school environment for TF became unbearable. KS and CS attended a class together at Seneca Valley Intermediate High School. On March 26, 2018, other students overheard KS preparing CS for a false statement. CS would be providing to a guidance counselor regarding TF. Listen and believe. Listen and believe. What reason? What reason did they have to lie? What reason do they have to lie? Have you guys figured out the reason to lie yet? Have you? Have you figured out the reason to lie? What reason? Why would they make this up? Why would any woman or girl or anybody make this up. What reason? What reason do they have? KS walked CS to the office of the guidance counselor. CS falsely reported to a guidance counselor that TF had entered her home uninvited and that he had sexually assaulted her. Childline was contacted. CS, ES, and HR were interviewed by the Butler County Alliance for Children. HR provided conflicting accounts of the event of the evening. The Zelenopol police conducted absolutely no investigation into the allegations of CS, ES, and HR. Why would they? Why would they? It's not their job to get you out of crime. Remember this. It's not their job to get you out of crime. Police think people think that the investigation is this magical thing that occurs. This magical thing where they thoroughly vet all of the charges. And maybe they come up with exculpatory evidence. Maybe that they come up with this exculpatory evidence and then they say, you know what, we don't have enough to convict on this because this all turns out to be bogus. If they have a reason to find it. But what reason do they have to find it here? What reason do they have? All right. No investigation of the allegations of CS, ES, and HR, and neither the police nor the district attorney's office seized the mobile phones of CS, ES, or HR to determine if they contained any information pertinent to their allegations. Sorry, got a baby slamming on a glass door. CS, ES, and HR repeated their lies about TF to other students and anyone else who would listen to them. TF was harassed in the days following March 23rd, 2018 by students asking if he and CS had done something. It should be their job to not put an innocent person in jail. It should. But their job is to prove them guilty beyond a reasonable doubt, right? That's the prosecution's job. Police are on the side of the prosecution. April 9th, 2018. TF was charged with the offenses of indecent assault, forcible compulsion, criminal trespass, and simple assault on April 10th. Just a second. I think she's about done. I don't know what Lady Rackets is doing right now. On April 10th, 2018, a petition alleging delinquency was filed against TF. Hold on. This is driving me nuts. Just a second. This is good TV right here. Oh my goodness. All right. Okay, a petition alleging delinquency was filed against TF alleging indecent assault, forcible compulsion, felony criminal trespass, and simple assault. On April 10th, he was removed from class at Seneca Valley High School and placed in leg and wrist shackles. Because that always looks great, right? That's good. That's good for the old personal reputation of TF. Is to be taken in leg and wrist shackles by the Jackson Township Police with the assistance of Juvenile Probation Officer Michael Trago. Transported to Keystone Education Center, a juvenile detention facility. A hearing was held on April 11th, at which time Juvenile Probation Officer Michael Trago argued that TF was a threat to the community in an attempt to prolong his deprivation of liberty due to gender-based discrimination. TF denied the allegations of the petition and was incarcerated at Keystone Education Center for 9 days and 8 nights. And guys, I mean, if you don't know, 9 days is a long time. That's a long time to be incarcerated. No matter what it is. Like it's not a year, it's not a month or whatever. 9 days is a long time. A long time, especially when you've literally done nothing wrong. He had minimal contact with his parents, who retained and paid for legal counsel on behalf of TF to defend against the false allegations. He was released on house arrest on April 18th, 2018, with an ankle monitor and specific instructions from Michael Trago that he could not tell people about the ankle device, even though it was during some of the hottest days of, and he could not wear shorts or other clothing that revealed the ankle device even though it was during some of the hottest days of summer. He was not permitted to have any visitors, phone, or internet access, and could not leave the house except for therapy, which he requires to deal with the psychological trauma he suffered and to attend church. After 28 days, he was allowed outside the house only to mow his lawn, which he had to do in long pants regardless of the temperature. He was unable to play during most of the high school baseball season and was told by the athletic director that she was not sure he could play baseball because every time he was wearing a Seneca Valley jersey, he was representing the school. TF was unable to play baseball or work at his summer jobs for part of the summer. Because of the lies of CS, ES, and HR, and due to bias against males accused of sexual assault, Michael Trago treated TF more harshly than the situation warranted, denying him liberties to which other juveniles in similar situation would be entitled. TF received homebound instruction through the end of the school year and was deprived of his liberty for a total of 50 days. Being stuck at home for 50 days isn't so bad if you've got internet, right? But he doesn't. He doesn't even have internet. Trago gossiped about TF to teachers at the school where Michael Flood Jr. worked, who had no valid interest in the information provided, in violation of the Family Education Rights and Privacy Act of 1974, demonstrating gender-based discrimination TF and individuals in gender-based discrimination of TF and individuals in his position. Within 24 hours after TF had been arrested, his parents started digging into the facts. They found a male student who had also been invited to the Seaman residence on the evening of March 23rd and uncovered Snapchat messages from HR and ES indicating that they and CS had lied. Within a week, Mr. and Mrs. Flood had obtained several written statements to support the fact that the girls lured TF to the Seaman residence and fabricated lies about him. The Zelenopol police incompetently failed to obtain the aforedescribed exculpatory evidence, which the Floods easily obtained. Seneca Valley Intermediate School, a high school female student AK visited ES's house on May 30th. During that visit, CS, ES, and HR conspired about the false order of events that would be presented to investigating authorities, and they agreed to exclude the fact that they had consumed alcohol. The Mean Girls disclosed that HR used CS's phone to invite TF to the Seaman residence. He did not enter the residence uninvited. On April 15th, 2018, Seneca Valley Intermediate High School female student MM provided a statement that CS lied to authorities about TF's conduct and was passed out drunk on March 23rd. Seneca Valley Intermediate High School male student CH spoke with ES on April 21st. ES advised him that CS lied about everything regarding TF. A video recording of the conversation was preserved with the permission of ES. The statement of CH is attached as Exhibit 10. HR provided a 4-page statement that TF was invited to the Seaman residence but did not consume alcohol. CS was intoxicated and TF did not sexually assault anyone. On or about May 21st, Butler County Assistant District Attorney Russ Carl was provided some of the information gathered by Mr. and Mrs. Flood. May 21st, June, July, August, September, May 21st. On May 25th, he interviewed ES and HR who admitted to lying, and they stated that TF never committed a sexual assault. TF's ankle monitor was removed on or about May 29th. May 31st, 2018, Assistant District Attorney Carl interviewed CS who admitted that she also lied. She does not remember what happened at her house because she was drunk. On August 30th, 3 months after exculpatory evidence conclusively proving TF's innocence was provided to the Butler County District Attorney's Office, an order of the court was entered dismissing all charges against TF arising from the false allegations related to his visit at the Seaman residence. The case arising from the false allegations of KS was also closed by order of court on August 30th. TF was not released from court supervision due to the false KS allegations until an order of the court was entered on September 10th, 2018. The Butler County District Attorney's Office promised to file a petition to expunge the record of TF in September 2018, but has not yet done so, proving further evidence of gender-based discrimination. Butler County District Attorney's Office has refused to file criminal charges against KS, Megan Villegas, CS, ES, and HR due to gender-based discrimination against males falsely accused of sexual assault. Seneca Valley School District and Assistant Principal Aaron Mazer have refused to mark the academic records of KS, CS, ES, and HR to reflect that they lied to support unwarranted criminal charges against TF, claiming that their misconduct did not occur at school. How many times? Ooh. Were any of you guys ever called in for conduct that didn't occur at school? Were any of you guys ever threatened with disciplinary action for conduct outside of school? I was. I was absolutely threatened of that. We hear it all the time. All the time. TF's conduct wasn't done at school. Right? None of his stuff was. What was the point of denying him internet access if his crimes were not computer-based? Just had that thought now. You're curious? Yeah. Same thing as having him submit to random drug testing. Same thing. Same thing. There's no point. There's no point. Okay. Did not occur at school, even though the girls lied to a guidance counselor at school, triggering 2 separate cases charging TF with sexual assault. And even though the mean girls' lies to date have resulted in harassment and bullying of TF at school and at school-sponsored events, and even though the school district permitted, supported, and aided the Jackson Township Police in handcuffing and shackling TF during the school day and parading him out of the school into a police car, Seneca Valley School District failed to discipline the girls or mark their academic records due to gender-based discrimination against males falsely accused of sexual assault. This gender-based discrimination thing is Title IX, guys. That's what they're after here. That's why it's over and over again. The gender-based discrimination in the school context is a Title IX claim, and that's why they're laying it out. So they want to nail the school for a Title IX violation on this guy. Title IX's a gem. We're going to go through Title IX at some point. I hope these people burn for Title IX violations in this case, just because men falsely accused under Title IX get the hammer dropped on them. They get their academic and professional careers ruined. They don't have the criminal process even the weak criminal court system to protect them. They get nothing. Title IX is a disgrace, an absolute travesty. It's exploited over and over and over. All right. Ryan English says, case is slowly raising my blood pressure to a boil. Yeah. Well, let's keep going. I haven't read all this. I haven't read this case yet. I know about it, but I haven't read these documents, so I'm with you, buddy. Increasing in temperature. We'll see how the veins go. The mean girls will suffer no academic or personal consequences for their misconduct, which critically damage TF physically and psychologically and will impact his young life indefinitely. Isn't gender discrimination go against the 1964 Civil Rights Act? I'm Canadian, so I don't know U.S. law that well. I think so. I think it's sex-based discrimination, which under the law, under the Civil Rights Act is gender discrimination. However, I don't think that this amounts to gender discrimination in the education context under the Civil Rights Act. But I do think it matters under Title IX. It's a little different. Okay. All right. Let's keep going. As a direct and proximate result of the conduct of the defendants as described in this complaint, TF suffered the loss of his liberty, harassment in and out of school. When applying for colleges, he must explain his absence from Seneca Valley Intermediate High School, his incarceration at a juvenile detention facility, and that he opted to be schooled at home to avoid harassment and bullying at school, and to mitigate the impending anxiety of being taken from the school again, simply based on a false accusation. Psychological harm requiring medical treatment, harm to his reputation, and other damages and injuries which may become apparent during the pendency of this matter. Hey guys, do you think about that? When he applies to college and he says, look, I was falsely charged with sexual harassment stuff and they put me in jail and I had to finish out the school year at home. So you were falsely charged, huh? So you got out of those charges? Because that's how they'll hear it. I got out of those charges. They won't hear falsely charged. They won't hear falsely charged. They'll hear he beat the charges. You want that guy at your school? Twice in less than 6 months, accused of sexual assault? Let's see him get into a school. You're community college bound, TF. Sorry, buddy. You're only going to a school with open enrollment. As a further direct and proximate result of the conduct of the defendants, as described in this complaint, Michael and Alicia Ford were forced to endure observing the psychological harm and damages inflicted upon their son. They incurred attorney's fees and investigation fees associated with the defense of the false allegations against TF, and they endured the embarrassment and humiliation caused by gossip about their son, premised upon the aforedescribed false allegations. As a further proximate result of the conduct of the defendants as described in this complaint, TF has been forced to undergo medical and psychological treatment with the pain and suffering attendant to such treatment and may require further treatment in the future. Absolutely. You think this guy is going to be a normal functioning man in a relationship? Is that even a possibility anymore? That this guy has a chance at being in a normative relationship and being well functioning in it? Let's see. As a further proximate result of the conduct of the defendant as described in this complaint, Michael and Alicia Flood have been forced to spend considerable sums of money for medical treatment for TF, and they or TF may be required to expend considerable sums in the future. As a further direct and proximate result of the conduct of the defendants and described in this complaint, Michael, Alicia, and TF have endured and will in the future experience great pain, suffering, humiliation, embarrassment, inconvenience, and mental anguish. As a further proximate result of the conduct as described in this complaint, was unable to enjoy the ordinary pleasures of life, and they should put and will not be into the future. As a further direct and proximate result of the conduct of the defendants as described in this complaint, TF was unable to attend his usual daily duties during the period of his incarceration and confinement, and conduct of the defendants was willful and wanton and reckless disregard of the rights of the plaintiff, such that an award of punitive damages is warranted. And guys, I don't know if you've considered this. What if this guy had like a WoW account or a League of Legends, or was like a League of Legends player? That's like 9 months of no MMO for this guy. He's toast. Might as well turn in. I think that's the real crime here. That's the real crime. We got to keep focused on the important facts. This guy's WoW character is lagging significantly behind his guildmates. Count 1, negligence. The preceding paragraphs are incorporated by reference, as fully as if they were set forth at length herein. The damages and injuries suffered by the plaintiffs, which have been incorporated by reference, were directly and proximately caused by the negligence of the defendants in negligently failing to tell the truth. I mean, negligently failing to tell the truth. The TF never sexually assaulted anyone. The defendants owed plaintiffs a duty to tell the truth and not to lie about the conduct of TF. No, Andrew, it's not about the length of the subscription or the subscription cost. It's about he's 9 months out of the game. Wherefore the plaintiff demand judgment against the defendants in excess of the requisite amount for this court to exercise jurisdiction, plus cost of suit and any other relief determined to be appropriate by the court. Count 2, negligence. So this is the parents. Preceding paragraphs are incorporated by reference as fully as if they were set forth at length herein. The defendant parents negligently failed to supervise their children, negligently failed to teach them to refrain from falsely accusing another person of sexual assault. This is kind of a funny charge. Negligently failed to teach them the difference between right and wrong, negligently failed to teach them the golden rule, and David and Christine Seaman negligently failed to change their last name from Seaman to literally anything else. Negligently failed to supervise the minors at their residence who consumed alcohol, became drunk, and then lied about the conduct of TF. The parents also are vicariously liable for the negligence of their children. Furthermore, defendants Mr. and Mrs. Seaman negligently failed to store and secure the alcohol located inside their house, permitting the minors to gain access to the alcohol and subsequently lie about TF's behavior to cover up their misconduct. As a direct and proximate result, damages which have been incorporated by reference. Same thing. Same damages thing. Civil conspiracy. All right. Civil conspiracy is where two or more people conspire to commit a civil offense rather than a criminal one, right? You are knowingly going to commit some sort of tortious action against another person, and you group up and you plan it. You plan it in advance. This is not conspiracy is a crime of intent. Okay, it's not an incidental crime. It's not like you get wrapped up in a confluence of events where you end up causing some tort along with someone else. No, conspiracy is an intentional crime. You're planning with someone else to commit a crime. It's different from attempt, because attempt is the next step. Conspiracy is you're planning to commit the crime. All right. The proceeding, yeah, okay. Megan Villegas and KS conspired to falsely accuse TF of sexual assault for the purpose of getting him fired, and their conduct ultimately resulted in charges being filed against him. Their conduct was motivated by malice directed towards TF. KS conspired with CS, ES, and HR to accuse TF of sexual assault for the purpose of bullying and harassing him and causing him to be expelled from school, as well as endure legal proceedings. Their conduct was motivated by malice towards TF. Same thing, bunch of damages. Defamation. You think? KS, CS, ES, and HR falsely accused TF of sexual assault to school and court personnel, as well as prosecutors and other individuals. The statements harmed the reputation of TF and were made negligently or with actual malice. I think so. I think they satisfy actual malice. Actual malice, guys, if you don't know, is knowledge of their falsity or a reckless disregard for the falsity of the statements. They definitely had knowledge, as these were a lie, an out-and-out lie. The statements were published without any privilege whatsoever. Right. So privilege in this is interesting. This is a good thing to talk about. Privilege in a defamation case is different from any other privilege that we're talking about. What they mean by privilege in a defamation case is, and this is relevant to the diversity in comics lawsuit, because part of Mark Wade's defense is going to be privilege. All right. So pay attention to this if you care about that, even if you don't care about this. But you should care here, because this is good stuff. You can make statements about someone that turn out to be false, right? So actual malice is knowledge of the falsity. TF is not a public figure in a matter of public concern, so they shouldn't require actual malice even though they have it. But a negligent statement made with privilege, which is a legal reason to be providing that statement to someone, a negligent statement made with privilege might not be defamatory unless there's actual malice. Okay? So this is why this is all in here. And this is how a pleading is written. So they're made negligently or with actual malice. Actual malice being the catch-all, just in case they find out that this is a matter of public concern, so that there's reduced protection, or if they find there's privilege. But they're also saying that the statements were published without any privilege whatsoever. That's not necessarily true, right? The guidance counselor overhearing the first statement and then asking the girl to come in and testify, or the teacher overhearing and encouraging her to go to the guidance counselor. The statements made to the guidance counselor likely were privileged or could be found. Well, to be charitable, they could be found to be privileged because a guidance counselor has a legal right and a legal duty to obtain statements from students about what's going on in their lives to help them foster a positive education environment. Okay. So there is a duty of a guidance counselor to collect statements of the sort that were provided, and they would be privileged in the sense of defamation, where having the duty to provide them would mean if they were wrong, but negligently so rather than maliciously so, they might be excluded. They're covering all the bases here, and they should, but that's how this goes. I hope that was clear. I know that's a little muddy, but it's not like privilege in other areas. This is a specific privilege relating to defamation cases. So if that doesn't make sense, super chat me $200 and I'll call you personally and we'll talk about it for an hour. Plaintiffs are entitled to recover damages pursuant to 42 PACS 8343. Plaintiffs are private figures under Pennsylvania law. So there's the public figure doctrine that they're eliminating. And I think I agree. The court would still have to look at this, but I agree. TF suffered actual damage to his reputation and loss of liberty due to defendant's false and defamatory statement communications. And then this next one's important. In addition to aforedescribed statutory remedy, plaintiffs are entitled to recover for slander per se pursuant to Pennsylvania common law. And that's because he's alleged of a serious crime of moral turpitude with sexual assault and simple battery and all of those things. Those are crimes of moral turpitude, and falsely alleging someone to be guilty of criminal acts of moral turpitude is an automatic damage, a per se damage. The damages are presumed by the court, and it doesn't matter if he suffered actual measurable damages from those statements. So there we go. There we go. As a direct and proximate result of the defamatory statements published by the defendants, plaintiffs suffered those damages and injuries which have been incorporated by reference. Lots of damages. Malicious prosecution. Yeah, get them. Get them. They're going to lose this one, I think. Maybe not because of the 3-month delay, but I think they're going to lose this one because who wants to hold prosecutors and cops responsible for being the worst at their job? At what their job is supposed to be. Not what their job is. They're great at that. Who wants to hold these people responsible? Who wants to punish them for making a mistake, even if that mistake was mistake. We're being generous. We're being generous. KSCS, ES, and HR knowingly provided false statements to school and court officials and to prosecutors to initiate criminal prosecution of TF. They maliciously prosecuted proceedings against TF when they knew that he did not commit sexual assault or other crimes alleged against him. The claims were brought without any cause whatsoever, let alone probable cause. I'm going to disagree. Under pretty much, I'm not, with the caveat that I am not versed in Pennsylvania case law. To the cops' credit, the information they were provided largely supports probable cause in this case to bring the charges or to at least make the arrest. Whether the attorney should have brought probable cause without any real investigation to exculpatory evidence, I don't know. They had corroborating witness statements. It's really hard to argue that they didn't have probable cause. It's a much lower bar than people want it to be. It's a lower bar than it should be, frankly. But yeah. They say without any cause whatsoever. So we'll see. We'll see. And the actions were terminated and dismissed in favor of TF. That's an ex post facto argument. The question is, at the time of the arrest and the prosecution, did they have probable cause? And I do think they did, although there may be some arguments about the negligent actions. But again, it's up to the court. It's up to the court. I hope they nail them to the wall, but I just have no faith in prosecuting the prosecutors. All right. So we'll see. As a direct and proximate result of the malicious prosecution initiated by the defendants, plaintiffs suffered damages and injuries which have been incorporated by reference. Invasion of privacy. Conduct of the defendants caused an intrusion upon the solitude or seclusion of TF and his parents and their private affairs and concerns. The intrusion was intentional, substantial, and of a kind that would be highly offensive to the ordinary, reasonable person. Conduct was of a sort that would tend to cause mental suffering, shame, or humiliation to a person of ordinary sensibilities. Conduct of the defendants also placed TF in a false light by publishing highly offensive false statements with knowledge of reckless disregard of their falsity to create a false and highly offensive impression of TF. False allegations of sexual assault are highly offensive to the ordinary reasonable person. The defendants acted with knowledge and that the statements were false and with reckless disregard to their falsity. Damages. Intentional infliction of emotional distress. And this is a good one because I think they have a really good case on this one. And intentional infliction is a hard case to show in a lot of instances because the conduct, so they're going to talk about this, but let me read it and then I'll talk about it. The conduct of Megan Villegas, KS, CS, ES, and HR, as described in this complaint, was extreme and outrageous, intentionally or recklessly causing severe emotional distress to TF. Extreme and outrageous conduct of the mean girl defendants went beyond all possible bounds of decency and would be regarded as atrocious and utterly intolerable in a civilized community. And that is the legal standard for intentional infliction of emotional distress laid out in the King's English. It has to be extreme and outrageous conduct. It has to be beyond what anybody would think acceptable, right? Calling someone mean words, not infliction of emotional distress, unless you're really calling them mean words. Accusing someone of criminal sexual behavior to the point where they get arrested and incarcerated and put through the criminal process, way outside the bounds of civilized society. Way outside. As a direct and proximate result of the conduct of the defendants, plaintiffs suffered those damages and injuries incorporated by reference. TF suffered severe emotional distress, meaning that it is such that no reasonable person could be expected to endure it, and included highly unpleasant mental reactions such as fright, horror, grief, shame, humiliation, embarrassment, worry, and all other damages and injuries pleaded in this complaint. Absolutely. Absolutely. Like, we're talking real trauma. This kid would be afraid to go to school. This kid would be afraid to go out in public. This kid would be afraid to go to the grocery store. Have you guys ever talked to someone accused of sexual assault? If you have talked to someone, you know that if they've been publicly accused by sexual assault, they don't go outside anymore. They don't go to the store. They don't go anywhere. Or typically, like if they're normal people, they can't deal with it because everyone looks at them. Their face has been in the paper. I live in a small town. If you're accused of sexual assault in this town, everyone knows it. Everyone knows it. All right. Damages. Abuse of process. Defendants Megan Villegas, KS, CS, ES, and HR used a legal process resulting in the arrest, prosecution, detention of TF to accomplish a purpose for which it was not designed, as described in this complaint, including bullying and harassment. Damages. Injurious falsehood, disparagement. They published untrue statements regarding TF that they knew or should have known would likely result in financial harm to TF caused by the actions of third persons relying on the statements, such as criminal defense fees, bills for medical treatment, and other financial harm detailed in the complaint. Statements were motivated by ill will towards TF. The defendants intended to interfere with TF's interests in a way which were not privileged to do, and defendants knew that the statements were untrue. Fraudulent misrepresentations. Hey, what's up, Adam Smith? The defendants Megan Villegas, KS, CS, ES, and HR knowingly made the aforedescribed material misrepresentations regarding the conduct of TF. These misrepresentations were made with the intention of inducing third parties to act in reliance on it. TF was fired from his job at Zelenopol Community Pool and was arrested, prosecuted, and detained for false allegations of sexual assault due to defendants' fraudulent misrepresentations. Violation of 14th Amendment of the U.S. Constitution brought pursuant to 42 U.S.C. Section 1983. Guys, I've reached a conclusion that is making my blood boil, and I'm saving it to the end, but I am seething right now. Liability of a municipality or other local government entity arises where a government causes an employee to violate another's constitutional rights by an official custom or policy. A policy exists when a decision maker processing final authority to establish public policy with respect to the action issues an official proclamation, policy, or edict. A custom is an act that has not been formally approved by an appropriate decision maker, but that is so widespread as to have the force of law. A policy or custom may also be established when a policymaker has failed to act affirmatively at all, though the need to take some action to control the agents of the government is so obvious in the inadequacy of existing practice, so likely to result in the violation of constitutional rights, that the policymaker can reasonably be said to have been deliberately indifferent to the need. The government entity exhibits deliberate indifference when it disregards a known or obvious consequence of its action. All right. Scottius Maximus I says, "Hey Nick, a 5-minute walk from my home is the recently built sex offenders registry. It's right next to a school. How messed up is that?" Oh, that's the civil planning hallmark, right? That's the greatest possible outcome that they could have. Good job, guys. Oh, my goodness. The 14th Amendment of the United States Constitution provides that no state shall deny any person within its jurisdiction the equal protection of the law. So aren't you... You're sending that in pounds. I have to imagine you're in the UK. Don't you guys have ridiculous zoning requirements? Defendant Seneca Valley School District, Butler County School District, or Butler County District Attorney's Office in Butler County, Pennsylvania, denied TF the equal protection of law based upon his gender. And I don't know how well they're going to do on this claim, but this happens everywhere. Everywhere. You want a men's issue? You deal with men versus women in court in anything involving the word assault. You better be good at running uphill, because you're gonna be Sisyphus. You're gonna be greased up feet on a greased up hill, and you're gonna be trying to run up against everything, and there's a bunch of spears behind you. Good luck. Good luck. Let's see. Butler County, Pennsylvania, and the Butler County District Attorney's Office failed to prosecute the females who falsely accused TF of sexual assault, even though they vigorously prosecuted TF to the fullest extent of the law for false allegations against him. Butler County, Pennsylvania, and Butler County District Attorney's Office have a policy that results in reverse discrimination based upon gender. Reverse discrimination is not appropriate here, in my opinion. It's just discrimination based upon gender. There's no reversal. Because men who are falsely accused of sexual assault are prosecuted to the fullest extent of the law, while women making false sexual assault allegations are not prosecuted at all. And this needs to be addressed. What they did is a crime. It's a crime. They have conclusive proof of the crime. They have admissions. That's the job of the police, to deal with that. The police and the district attorney. They need to be arrested and prosecuted. Absolutely. Absolutely. The Seneca Valley School District's policy also constitutes reverse gender discrimination because male students who harass or sexually assault women are disciplined and their academic records are marked to reflect misconduct, but female students who bully and harass male students with false sexual assault allegations suffer no discipline and no adverse effect on their academic records. A male student's right to be free from gender-based discrimination, gender-based reverse discrimination, is a clearly defined constitutional right. Defendant's failure to prosecute the females who harassed TF and made false allegations against him, and the failure to discipline them and mark their academic records violated TF's equal protection rights guaranteed by the 14th Amendment. The aforesaid policy of Butler County, Pennsylvania, was implemented by the attorneys of the Butler County District Attorney's Office. The aforedescribed policy of the Seneca Valley School District was implemented by its administration and the Seneca Valley Intermediate High School's administration, including but not limited to its principal, assistant principal, and guidance counselors. In the alternative, the aforesaid policies or customs exist as a result of the failure of decision makers at Butler County and Seneca Valley School District to act at all. The policy or custom of the defendants creates a risk to males like TF because they result in there being no deterrent against women who make false sexual assault claims against men, resulting in a deprivation of the right to equal protection guaranteed by the 14th Amendment for males such as TF. Defendants are liable under 42 U.S.C. 1983 for deprivation of federal right due to the aforedescribed policy or custom pursuant to Monell versus Department of Social Services. It's so wide. The custom is so widespread as to have the force of law. Defendants have failed to act affirmatively at all, although the need to take some action to control agents of the government is so obvious and the inadequacy of existing practice so likely to result in the violation of constitutional rights that the policymaker can reasonably be said to have been deliberately indifferent to the need, resulting in the deprivation of TF's constitutional rights. The custom and policy were direct cause of harm to TF. Tess, that's a good question. Tess asks what amount of punitive damages would be enough for complete destruction of character and irreparable harm to his future career. I don't know. How do you even quantify it? How do you even begin? It's 7 to 8 figures, in my opinion. 7 to 8 figures. is the only way to do it. Because a 7 to 8 figure judgment also is a statement. It's like, yeah, not only did I beat these charges, but they had to pay me $12 million, you know, or something like that. But I think it's somewhere on the upper end of 7 figures to the lower end of 8 figures. This kid is a kid. He's not out of college yet. We have no idea what type of career he could have had. He wasn't a dropout from high school. So he presumably has 60 years of work, 50 to 60 years of working age in front of him, even at a low or middle class rate. Even at a middle class rate, that's a lot of money. That's a lot of money. So, you know, plus attorney's fees, and the attorney's fees on this are going to be big. John Russell, possibly something like the average lifetime income of a person with their IQ. Maybe. I don't think the courts would use an IQ test. What they do is like a prospective economic advantage. They probably just pick, you know, some sort of middle class position, based on, you know, their age and education, cost of living and all that, you know, in the Pennsylvania area, which I have to assume is a little bit high. But yeah, I mean, it's really got to be upper 7, low 8s, in my opinion. Okay. Furthermore, TF suffered irrational and wholly arbitrary treatment by the defendants because he was arrested, detained, and prosecuted. His academic record was tarnished, but his tormentors suffered no repercussions whatsoever, resulting in a class of 1 equal protection violation by the defendants. As a direct and proximate result, damages. Damages. Gender discrimination under Title IX. Seneca Valley School District receives federal financial assistance. TF was subject to gender-based discrimination by the Seneca Valley School District, which reported the false allegations of sexual assault against TF to governmental authorities for investigation and prosecution, and placed a black mark on his academic record, including unexcused absence from school and the need to withdraw from school due to harassment by other students, but failed to render any discipline whatsoever to the females who bullied and harassed a male student and falsely accused him of sexual assault. What reason did they have to lie, Christine Blasey Ford? What reason? What reason, Michael Avenatti? What reason did they have to lie? Michael Avenatti, whose face looks like a penis, sexually assaults everyone just by showing his ugly face on TV. Michael Stupid Avenatti, you got fooled by a Navy SEAL sniper meme, you edgelord. Retire, you idiot. Sorry, that was a sidetrack. Michael Avenatti needs to be disbarred and shipped somewhere. All right. They failed to render any discipline whatsoever to the females who bullied and harassed a male student and falsely accused him of sexual assault. The conduct of defendants creates the substantial risk that male students in the same position as TF who are falsely accused of sexual assault will suffer harm because the female students tormenting them suffer no risk of any consequences whatsoever due to their misconduct. Seneca Valley School District's response to the harassment of TF by the female students and the other students who continue to harass him due to the Mean Girls' false sexual assault allegations amounted to deliberate indifference based solely upon his gender. Demand judgment against the defendants in excess of the requisite amount for this court to exercise jurisdiction, plus cost of suit, attorney's fees, and all other relief determined to be appropriate by the court. Plaintiffs demand a trial by jury on all counts in this complaint. Yes. Do it. Win. Because the cops deserve to eat one on this, even though it's the taxpayers of Pennsylvania who get to suffer for this. Because what's going to happen to the district attorney? Let's say they lose. Let's say they lose their 1983 claim. They're not paying it. The district attorney's office is paying it through the taxes of Butler County. Property taxes are going up. Well, the cops lose. What are they going to do? Arrest them? They're not going to get criminal charges. No one's getting fired over this. If they lose, it's paid for by the police department, which is paid for by state budget of the state of Pennsylvania. Property value taxes are going up. Isn't it great? Isn't it great? What person suffers a consequence here? The only hope is that the girls' poor parents, the poor parents of these disgusting teenage girls, will have to suffer on behalf of their teenage daughters. The girls will never suffer anything. They should arrest them. What they did is a crime. It's perjury. It's a felony. You know, all of that's illegal. Like, not just civilly unlegal. That's an actual crime. They could go to jail. They could go to jail for over a year for what they did. Not even a charge. Not even a charge. People out there are still wondering if they're going to charge Christine Blasey Ford for her crime, right? For Brett Kavanaugh. They're wondering if she could be charged with the crime. Look at the evidence that they have. We did it. They have that. And they won't charge him. You think they're going to charge Ford? Nah. If the cops cause a payout in a case like this, does it go in their employment records? I don't know. I don't know enough about that. Might be department to department, might be case by case. I highly doubt it. The way police offices work in regards to courts is that typically the every individual officer is infused with all of the knowledge of every other officer when it suits them. So I would have to think that no, they'd just be doing their job. But no, how are they going to charge? They won't even charge these girls who clearly violated the law with every false statement. They violated the law with criminal conspiracy. That's criminal conspiracy against them. They're not charged with that. And then the false statements are lying to creating a false police report. That's a felony, I believe. It is in Minnesota. I don't know if it is in Pennsylvania. I would assume so. Falsifying a police report. And then, making the false statements to government officials. Typically a crime. Yeah. It's like icing in hockey. It hardly ever gets called out. Absolutely. It only gets called out if you're a Republican staffer on Donald Trump's campaign, right? Then you get charged with lying under oath. Then you get charged with perjury. But you don't. You don't if you're just ruining someone's life other than Hillary Clinton's afterlife. Like, if you're not ruining the undead husk that is Hillary Clinton, then who cares about perjury, right? Like, and I hate to be that political guy. I really do. But oh my goodness. What do we have? We have this system where they've ruined a kid. They've ruined him. Whether or not, even if he gets accepted to colleges, how's he going to do it? How's he going to date? How's he going to get married? How's he going to function in a group setting? If he gets accepted, what kind of job's he going to get? Is he going to get a job where he works with a lot of women? Is he going to be apprehensive in interviews if there's a woman present? Is he going to be afraid to be around another woman for maybe like a lunch or something like that? Or in an office with another woman who might be a manager over him for a promotion? Is he going to be nervous and anxious and come across poorly? Like, there are immeasurable and intangible effects to this. His life is ruined. Why do we care about this stuff? Why shouldn't we just listen and believe? Listening and believing is good for therapy. Make no mistake. This is where everyone has gotten this thing mixed up. It's good for therapy. It's good to listen and be there and to offer compassion and support to someone. They may not in this case. In this case, these are scumbags. But let's talk Kavanaugh for a second. Let's say Ford genuinely believes that Kavanaugh did it. And let's say, even though we can never know, that Kavanaugh didn't do it, but that because of years, decades passing, that Kavanaugh's face was put onto the body of an actual perpetrator against Christine Ford because she didn't recognize the perpetrator, was drinking that night, And because she did recognize Kavanaugh as someone that she knew, associated with, maybe was attracted to, I don't know, years ago. Let's say that happened. Let's say that she was assaulted by someone else, and then 3 decades later, through some therapy, through reconstructive memory, her brain erroneously puts his face on someone else's actions. This happens probably a ton. And if Brett Kavanaugh's not running for Supreme Court and she never sees him again, really no harm, no foul, right? Like if she's never forced to interact with him again, that's fine. So she remembers someone doing something, and if it helps her get better, okay. Because how else do you get past the event? This is the theory. How else do you get past the event without constructing the memory, getting to it, and then processing and dealing with it? Something that's been suppressed or repressed all of these years. That's the therapy theory. Works great in therapy because it doesn't harm the person who is the alleged perpetrator in therapy. It just allows the alleged victim to process what happened. Until they run for the Supreme Court. And then you start saying it as if it's true. And you can't know. And we can't prove it. This is why we can't listen and believe in a legal context or in any context where someone else's reputation is on the line. Because if there's a therapeutic reason for her to remember Brett Kavanaugh and that's beneficial to her, that is a good thing until it impacts Brett Kavanaugh. Then we need facts. Then we need real facts. And if you can't find the real facts, you shouldn't even be talking about it. None of this should have been in public. In my personal opinion, none of this should have been in public. It should have been investigated quietly. They had the letter plenty long to discuss this with people. This should not have been in the Senate Judiciary Committee until they had any corroborating evidence or any evidence at all, even like a date or a location or something. But this is why we don't just listen and believe. This is why we can't, as a society, in public, listen and believe. When your friends come to you, and your friends need support because something has happened to them that's awful and they're processing it, listen and believe. You don't want to like critically dissect their experience. That's not your job at that moment, right? You listen, you believe, you offer compassion and support. When they start to go to the police and the police come and talk to you, you say, I don't know anything about that. They told me some stuff. I don't know anything about that. That's how that should go. That's unfortunately not how it goes. Because we listen and believe to a bunch of people who make up lies. Do you suspect that the Republicans will retaliate against a Democrat-nominated Supreme Court justice with the same accusations? Yeah, 100%. I think they do. And you bought it. You bought it, dummies. You nuked the 60 votes because you really wanted that 51 vote to get Supreme Court justices. You were warned by a deformed, mentally handicapped turtle named Mitch McConnell that this will come back to bite you. This will come back to bite you sooner than you know it. Just so you know. Mitch McConnell warned you, you idiots. You got warned by one of the lamest people on earth what would happen when you did that. And you did it anyway. Because you're stupid. You have no foresight. You've no foresight. You never thought you were going to lose power. I guess. But yeah, Republicans are absolutely going to do it. No Supreme Court justice nomination from here on out will be smooth. And if it is, you should be suspicious. Oh my gosh. What a disaster. But anyways, guys, so I saw this in the news. I saw this case in the news. I wanted to talk about it because of Kavanaugh, because a lot of people are talking about Kavanaugh, but I thought this was a good way to illustrate the problem with listen and believe in a legal context. I can't stress that enough. Guys, if you have friends who have been assaulted, listen and believe for them. Do that. Help them. When they start going to the police and start bringing the other person into it, then you can be skeptical. But in the meanwhile, care and support for the people around you who you love. Absolutely. But But we can't listen and believe in a legal context. That's not how the system works. Presumption of innocence is it's one of the most critical factors of living in a free society. And we don't have it. We don't have it. We have something getting to it. Actually, we're on the boat sailing away as fast as possible. But we don't have it. Ask someone accused of a crime how innocent they feel. Anyway. Yeah, exactly, Super Iron Bob. Don't destroy the other person's life while believing. You listen and believe in a supportive, compassionate capacity. That's what it's designed for. That's the origins of listen and believe, and that's where it belongs. Doesn't belong in Title IX. It doesn't belong in a court, and it doesn't belong in a Senate hearing. It doesn't belong in any official thing. It doesn't belong in a public forum. It doesn't belong anywhere like that. That needs to be based on facts, evidence, and the ability of the person to answer, credibly answer, and be given full deference. That doesn't happen in any of the forums where it's been going on lately. So, yeah. Well, guys, I mean, I think that's it for tonight. I hope this has been helpful. I hope this has been a unique way to look at these false allegations. Like I said, I've been wanting to talk about Kavanaugh, but everybody's been talking about Kavanaugh, and they've all been doing it in the same way. I thought an analogy, an example of why listen and believe is really a dangerous legal standard. Once I saw this case, I was like, that's good. That's good. We'll talk about that. So I hope that helps. Yeah. Was there anything you guys need me to talk about before we shut down? Like I said, tomorrow is John Della Rose. I'm strongly considering a Saturday stream. I'm not sure what time to go through that 87 pages of Google goodness. And we're going to talk more about free speech. And maybe there will be screaming involved because I really, really hate these tech companies right now. Really hating it. I'm really hating it. Kikagazumi says, this has been very helpful. Thank you. Well, thank you right back. Your super chats and regular chats are very helpful for me too. I love engaging with you guys and talking about this stuff. So, but yeah, we do have, tomorrow for sure, John Della Rose. Come watch that. If you're at all interested in comics, if you're at all concerned about speech, guys, I never thought I would be talking about comics. I never thought I'd be talking about comics ever in my life. I haven't bought comics in so long. And now it's, to me, it is at the forefront of the war on speech, the war on expression, the war on art, the war on political opinion. It's the forefront. It's freaking comic books. What happened? What stupid world are we in where comic books have become this important in the general, and people don't know. That's the other thing. And I think that's why the wars have been happening inside the nerd community. We've gone through video games, we're going through movies, cartoons. It's been happening for a while, and it's gotten to comic books. But here's the thing. Comic books can fight back because of the medium and how it works and the tools we have now. Comic books can fight back, and it is our chance to start reimposing ourselves in the culture war. And when I mean ourselves, I'm talking about people who believe in the liberty of thought and speech. That's what needs to unite us. It doesn't have to be political opinion. It doesn't have to be uniformity of what thought and speech is correct or good, other than all of it. All of it has to be good. All of it. All the words we can't say on YouTube, those have to be fine. Dressing up as in yellow face or black face, or dressing up as an Indian with the feathers on your head, or dressing up as an Indian with a dot on your head, dressing up as a Mexican with a giant sombrero and mustache and a La Cucaracha guitar. All of that has to be okay. It has to. You cannot like it. You cannot want to deal with it. You don't have to talk to that person or whatever, but you have to stop trying to censor them. the most liberal speech, the most conservative speech, the most incorrect speech has to be okay. We've got to unite on this stuff. We've got to, or we're done. And if you don't believe we're done, you're wrong. I'm sorry. Let me do a couple super chats here. Remember Emmett Till from Brad Burns. Yes, remember Emmett Till. And I am working. So as you probably know, I passed 11,000 subscribers now. I'm working on a 10,000 subscriber thank you extravaganza video. And I have a guest who I have been dying to get on the show. You guys don't know him. You don't know who he is. You've never heard of him probably, unless you're a personal friend of mine. Then you've heard of him. You know exactly who I'm talking about. It's the guy that I was dressed up as for Halloween that people have tried to use to silence me in various ways. I am going to work really hard to get a live stream. I think you guys are going to love him. And we will be talking about false allegations. We will be talking about the realities of interpersonal relationships between men and women. He's one of my favorite people to talk to, and I want to do that with you guys. I think it'll be great. So know that I do have a hopeful plan for a 10K subscriber video, but getting me and him in the same room on the same schedule has been very difficult, just due to him being a very busy guy, me being a busy guy, and each of us having kids. That just complicates everything. So I'm going to try and do that as soon as possible. So I will make a big announcement if I can lock that down. Otherwise, I will come up with some sort of other thing. But I think that'll be an epic stream, in my opinion. Hopefully you guys will enjoy it too. Big Guy says, thanks, Wrecked Law. Thank you, Big Guy. I appreciate it very much. True American Hero says, Gamergate 2.0, spread the word. Yeah, someone get Trump to tweet out Gamergate, right? Like to tweet about it. I think that's definitely in the social zeitgeist, and that needs to happen. Super Iron Bob says, for shoe polish, thanks for covering this. It brought up some bad memories for me. Oh, I'm sorry, buddy. Sorry, buddy. I did not mean to bring up bad memories for people, but... Adam Smith says, Black Friend, get hyped. Ryan English, a Battletoads stream is a great idea. We'll maybe do that. We'll if I can book him for like a 3 or 4 hour stream, we'll do Battletoads. We'll do just conversation and everything. And I'll try and get it done before I would love to not get it done before the 20K subs because it happens so fast, but we'll see. All right, guys. Let's wrap this up. Thank you so much for joining me. Join me tomorrow, John Della Rose, Talking Freedom. We're going to be talking about that an Alt Hero Q comic book that was just deplatformed today from Indiegogo. We're going to see if we can get some more information about that. And then we're going to see, we're going to talk about John's case, of course, against Worldcon, being called a Nazi and kicked out of there. What that means, it's being brought in California, and the challenges that he faces there. So come join me. Thank you, guys. I'm gonna wrap up the stream here and go blank. And I will see you tomorrow. So you guys have a good night. Peace. And I'm working on an outro video, but, I'm really bad at that stuff.